A judge has ruled on the anti-discrimination language in the Affordable Care Act. This is Judge Reed O'Connor. He's a federal district judge in Texas. The case is Franciscan Alliance versus Azar. And this is a final judgment and opinion that came down on October 15th after 3 years of sitting idle in this court. Now, the decision coming out of Judge O'Connor vacated major parts of the rule to implement what is called Section 1557 of the Affordable Care Act. That is the section that explicitly prohibits discrimination based on gender identity and termination of pregnancy by providers, insurers, and others who offer coverage. Now, the judge said that this rule, 1557, this language violates the Administrative Procedures Act and the Religious Freedom Restoration Act. What his decision means is that providers are no longer required to provide services to transgender people if by doing so it would violate their religious beliefs. So a lot of people are not too proud of this judge for issuing this very restrictive decision, denying healthcare access and rights to transgender populations and redefining that gender identity language that the Affordable Care Act had tried to protect people with. Now, the judge did do something which might allow this case to be overturned. Before, he had prohibited the ACLU and the River City Gender Alliance from intervening in this case. He has now changed his mind and he will now allow them to intervene. This means that those two parties could appeal this decision to the Fifth Circuit Court of Appeals. They wouldn't have had the right to do that before. They weren't party to this litigation. We know that the Department of Justice was going to take no stance on this. They refused to defend 1557 and other parts of the Affordable Care Act. So in order for this to maybe be overturned, we needed somebody to intervene, and the judge allowed the ACLU and River City Gender Alliance to do just that. Now, we know Judge Reed O'Connor. He's the same judge who you might remember said the Affordable Care Act's individual mandate was unconstitutional. Now, meanwhile, while all of this is going on, the Trump administration is still rewriting the regulations around Section 1557. So we could still see more action coming out of the Trump administration while this lawsuit could be appealed and progressing through the courts. Now, you can read the judge's decision by clicking on the link in the description below. We will keep you posted on this case if it is appealed and if it does work its way through the courts and if the Trump administration writes that new 1557 rule. So make sure you subscribe to stay up to date.